and we won. And then there was a motion to reconsider, and we won. And then there was a motion to reconsider the motion to reconsider, and we won.
Next up happens to be page 7 of the calendar, and that's the estate of Wilfred Richard James Bosserman versus William Errico. Let's go ahead and set forth our appearances on the record.
Michael Van, bar number 3876, on behalf of the estate of Mr. Bosserman.
All right, good morning, sir.
Good morning, Your Honor. Matt Johnson on behalf of the defendants. Bar number
Okay.
6000.
Seems like Mr. Van, I've been with this case for a long time, and it's not going away for some reason.
It's every time we think it's done, it grows new legs.
Yeah.
And unfortunately, I've been with the case longer than you.
Oh, yeah, it's like
Your Honor, this is actually
Jason.
Yeah,
this keeps
exactly.
rising up.
This is actually a pretty simple issue.
I understand.
The court came down in April 7th and was very clear and said, here, there are 2 points that I want in the order. And so there was an order submitted that didn't include the 2 points. So we came back and said, nope, can't do that. Can we do it again? We had another hearing. Said, please include the 2 points. Nope, didn't happen. So we're back again. And in the most recent order, there's 3 sections in the transcript. And the first section has been included in the second.
I think I was pretty clear on this issue from the very outset of my involvement as the trial judge in this case.
Yes.
Right. It haven't deviated for what, 5 years?
No, you have not.
Okay.
So there's 3 sections. The first section, the third section are both in there. There's an ellipsis for the middle section. And I would just like to read to the court what we would just like included in the order. And it says from the transcript, what I'm going to do is this. As far as the motion to dismiss pursuant to the 5-year rule, I'm going to grant the motion. There's the order.
Right.
It's going to be without prejudice. That needs to be included.
I'm making specific findings on the record.
Exactly.
Yeah.
The reason here is twofold. Number one, so here's the rationale for the reasoning for the order. The procedural posture of this case and the attempt to defer to Mr. Errico's constitutional rights. There's the rationale. Because it has a criminal case discovery was delayed because of that. There's one.
Okay.
The second issue, very clear. Coupled with that, I'm going to also consider the disability of Wilfred Richard James Bosserman. And I remember, Mr. Johnson, we had a discussion at the very outset of this case, and it was a question regarding the potential tolling of the statute of limitations. And I had made a decision at that time that he suffered a mental disability based upon his mental status. And I think you probably remember that. It's probably in the record going back, way back, but that's the decision I made. All that we're asking is put that part of the transcript in the order. That's it. Mr. Johnson, and candidly, I don't think it's Mr. Johnson. I apologize. I think it's Mr. Errico that's writing this, and Mr. Johnson is being zealous in his representation. Can you please just order that part of the transcript be included in the order? That's all we're asking.
One thing I try to do as a trial judge, 2 things. If I'm going to rule a certain way, from the bench, I always try to tell you why. That's so important. That's what I did there. Secondly, if I take something under advisement, I don't just say granted, denied in my minute order. I'll tell you exactly why I ruled the way I did, because I think that's really important from a review perspective. And just as important, I owe it to the lawyers. That's kind of how I look at it. It's really that simple.
I agree.
Mr. Johnson.
Yes, Your Honor. Thank you. I appreciate the time to explain.
Absolutely.
This is our third time.
I always welcome you into my court, Mr. Johnson. Go ahead, sir.
Thank you, Your Honor. This is the third time we have argued this very issue. The last time we were here, they wanted the language quoted, and we've attached as Exhibit A to our opposition the language they wanted quoted. This came directly quoted from their reply brief, which was quoted directly verbatim from the transcript from the previous hearing, 3 hearings ago. We put exactly what you said. We quoted verbatim from their reply brief what they wanted in there. We quoted verbatim from the transcript what they wanted in there. Now, we didn't agree on orders. They submitted an order, you submitted an order. We came back to Your Honor and argued about which order was going to be entered. And Your Honor, after reviewing their order, and after reviewing our order, signed our order. And again, this is the third time. This language that they now want to add again is a subject of a motion for a more definite statement that I filed on March 5th, 2015, more than 7 years ago. We argued the statute of limitations issue, and you found back in 2015, you said, well, I don't think that, the statute of limitations could run against a disabled person, even though they already had a guardian appointed at that time. There was an order entered.
And especially under the facts of this case, because I do understand this. This case goes back to 2015, but I remember all the facts.
This is a 2013 case.
2013,
right?
I remember the facts.
So more than 7 years ago, you already addressed that issue. There was already an order entered more than 7 years ago. You granted in part and denied in part on August 14th, 2015. Again, more than 7 years ago. Entered by the court on August 20th, 2015, more than 7 years ago. And then again, that exact same issue was addressed again in another order, findings of facts and conclusions of law, dated April 20th, 2016, more than 6 years ago, page 3, paragraph 18, and it says, the court held a hearing regarding the tolling of the statute on July 28th, 2015. Where the motion to dismiss, motion to stay pending criminal trial, and counter motion for fees and costs were denied. So that's twice. You've already entered two orders with the language that they really want in there. You've already done it twice. Now, it's been more than 7 years since you made that finding. The court made findings 7 years ago, and the most recent evidence we have regarding the mental capacity of Mr. Bosserman, the very most recent evidence we have is a declaration. We've attached that as Exhibit B. That declaration comes from Plaintiff's Counsel. Plaintiff's Counsel, and it was Mr. John Holliday, puts at paragraph 15 of his declaration, and when I say 15, it's not really 15. He starts out paragraph 1, 2, 3, and then goes 14, 15. So I guess it's really 5. But what he says is, quote, and I'm going to quote what he said. This is the evidence. That's the most recent evidence. This was signed by Mr. Holliday October 27th, 2021, so just a little more than a year ago. He says, although he is not a vegetable and is verbal and understands the nature of this case. So the most recent evidence we have, Judge, is that Mr. Bosserman is not a vegetable, that he is verbal, and that he understands the nature of this case. Right?
Well,
So
I mean, if that's the case, then why did we open up an estate? This is the estate of William Bosserman, right? Why did we do that back in 2009?
In 2009?
Yeah, well, whenever it happened, but that's my point.
2009.
Well, 2009. He couldn't pursue this case in his individual capacity, is my understanding, because he had mental disabilities. That's why an estate was opened up for him, right?
The point, I agree. There was a case open in 2009 because he had that. The point that I'm trying to make is this. The findings, the order in this case, where you dismiss the case because the 5-year rule ran years ago, is you don't need to add additional language where you've already made that finding in 2 different orders. We haven't had a finding on that issue in 7 years. We quoted from your transcript. We quoted what they wanted. There is no reason to change this again. To make a finding now, 7 years later, on that issue, when you've already made that finding 7 years ago, more than 7 years ago, almost 8 years ago, it just seems to me that would, number one, it would be error. Number two, there's no reason.
How would it be error? That's what I want to know. How would that be error? Because I'm always concerned about this.
Because you're making a new finding that he's got this disability when the most recent, we haven't had any evidence or any briefing on that issue for more than 7 years. And the most recent evidence is an affidavit from their own counsel saying that he is verbal, that he does understand the case, and that he's not a vegetable. So I think that the best thing to do here is
leave the order. Only thing I can say about that is this. I don't mind saying this. I mean, I don't know if an affidavit by counsel pertaining to the mental capacity of a party in litigation would meet the Hallmark requirements. I really
I don't think it does. He's not an expert.
Okay.
But the bottom line is, here we are. Here we are. The case was filed in 2013. It's now 2022. 9 years, more than 9 years later, and we're arguing over adding some additional language from something that was found 7 years ago, when we quoted verbatim what they wanted. If you look at Exhibit A, page 3, to our opposition. This is the plaintiff's reply. This is the language last time we were here, what they wanted.
Here's my question, though, and I can't understand this. I don't mind saying this. This is very, very important as far as I'm concerned. I might sign 30, 40 orders a day, right? I do. And it's because we're very busy, got 1,000 cases and so on. But shouldn't the real issue be what I wanted in the order, right? Because I specifically made findings as to what I wanted in the order. And through oversight or whatever, if that language isn't there, what harm is there to cure the order? Because I specifically said that on the record. That's uncontroverted, right?
That you've done it twice, though, and gave us the opportunity to submit orders. We did. Originally, you signed our order. The second time around,
but here's my question. Once again, shouldn't it be what the trial judge wants in the order? Because at the end of the day, if there's going to be review, the reviewing court's going to want to know, and on some level, judge, did you make findings, right? And in this case, I actually made findings, right? It's not obscure. It's not a scenario where you can try to guess what the judge was doing or thinking. I specifically wanted to set it forth on the record for appellate purposes in case. Or, just as important too, there might be another case down the road. I don't know. But I didn't want my order, and I'll tell everyone this because this is my thought. I didn't want my order to be used as a sword, right?
And I don't want it to be either, Judge, and that's why I'm saying you've given us, this is the third opportunity, and we did exactly, we quoted what they wanted, we quoted what you said. You saw two orders. One was presented by them, one was presented by us this last time. This is the third go-round. And you signed our order over their order because we quoted verbatim from the transcript and from what they wanted. So I'm not sure why, I don't want it to be used as sword either, and that's why I'm saying don't go putting that back in here, 7 years later when you've already looked at the issue three times now. This is the third time. All right. And I don't see where, where adding the additional language that was not what they requested last time. And if you recall, last time they were late on their motion for reconsideration by, a month and a half or so, and you still said, you know what, I'm going to do it anyway, and you did. And then when we couldn't agree on the order the second go-round, you told us both submit competing orders. We did, and then we had a hearing, and you said, you know what, I'm going to go ahead and sign the defendant's version of the order. So it's already been issued. It's already been addressed. I'm not sure why we're reconsidering it again a third time, particularly when it was quoted from what they wanted and what you stated on the transcript.
And Mr. Johnson, thank you, sir, and we'll hear from the reply.
Thank you.
Your Honor, I don't think the number of times is as important as that we get it right. That's the most important thing. I think that the court hit the nail on the head when you said, isn't it important because of what's probably coming in the future? We know that. It's important that that dialogue from the court be included in the order. Very important. A couple of things, and this really has no merit for this. It's just because Mr. Johnson, you're right, this is a long case. Let's remember about this case. We filed the case. It took 2 years to get an answer because of motions to dismiss, and we won. And then there was a motion to reconsider, and we won. And then there was a motion to reconsider the motion to reconsider, and we won. And then there was another one. And the judge says, oh, you know what, to stop all of this, let's file an amended complaint. And then there was a motion to dismiss, and then a motion to reconsider it. This thing went on for 2 years before we got an answer. It's not like we've been sitting back doing nothing. It's because this has been just absolute chaos from the outset. We have now an issue.
Well, I won't go that far, but understand this. This is kind of how I look at this case, and there's no question. It has a unique procedural posture. I'll say it that way, right? And not just those issues, but also delaying the prosecution of the case based upon the Fifth Amendment rights of Mr. Errico, and he had the pending criminal matter and all these things. And I permitted you to kick the can down the road. And so my point is this: I didn't really and truly think the delay was at the fault of anyone. It was mutually agreed upon.
Agreed.
Because you wanted the criminal trial to occur and then move forward. Okay, and then at the very end, there became a disagreement, and the case ended up in the procedural posture that it ended up in. And then I did what I had to do. But just as important too, I wanted to make sure that my comments were contained in the order. So down the road, there would be no confusion as to why I did what I did and what my findings were.
And all that we want is their prior order and add that middle section of the transcript in there,
Yes,
which I've already read. And so we'll take their order. If Mr. Johnson will send it over to me in a Word version, we will insert that section. I'll get his approval and we'll submit the order.
All right. And what I'm going to do as far as the motion is concerned, and I do agree with you in this point, sir, we want to get it right. We do, and that's the bottom line. And I think whether I was right or wrong, that'll be up to another court to decide. But I think from a fundamental fairness perspective, it's important to have the reason why I did what I did and what my findings were as far as the case is concerned. It just is, because I just know what a reviewing court would want to know. What was Judge Williams doing with this, right? And they're going to want to know that. Granted.
Thank you, Your Honor.
Your Honor, the last issue that was not addressed yet was our request that they obey the order that's been entered since May with respect to the documents that are sealed, that they be returned, that they be deleted from their server and those sorts of things. And that still has not happened. And here we are, 7, 8 months later, still hasn't happened.
I'll send an affidavit that they've been destroyed.
Mr. Van has just said he'll prepare an affidavit to attest to the fact that they've been destroyed.
But they haven't been sent back like the order required to us. We have not received those.
I don't think we have them anymore. Everything is paperless. We've been shredding everything, so we've got everything.
This is what we'll do. I'll make this really easy for you. You don't have to make a decision right now. We'll set it for a status check regarding that issue. You can appear telephonically.
Okay.
So you don't have to spend, and Mr. Johnson, of course, telephonically. And just a status check on the status of the document, say sometime at the end of the first month of January. That way you have enough time, and maybe we'll appear to status check, and Mr. Johnson, you might feel, okay, I feel that we have enough information here. I'm not concerned. I don't know, but we don't need to address it right now.
Okay.
And if you have mutual agreement, you can call me. I'll vacate the status check.
Okay.
Okay.
January 26th at 9 a.m.
How about January 26th at 9 o'clock a.m.?
Let me look.
Thank you, Your Honor. Will you do one last favor? Have a nice holiday.
Okay.
Thank you.
Everyone enjoy your holiday.
9 a.m. January 26th, correct, Your Honor?
Correct, Mr. Johnson?
Okay, thank you.
Okay, enjoy your day.
You too.
All right. Okay, we're going to move on.